We have seen recently that Supreme Court unusually has focused more on the issue of the bail. Though bail is always the provision of Criminal Procedure Code, it was always there in the older ones, and it is also newly inducted BNSS, Bharatiya Nyaya Sanghita. Uh, so we have the basic thing in polity. How do we understand the question of bail or jail in terms of rights of the person? We have to understand this issue in terms of rights. And when we talk about the rights, we have to understand these rights related to this topic from the angle of human rights as well as from the angle of fundamental rights. Fundamental rights, right? So, when a person is convicted and sent to jail, when a person is detained and sent to jail, then the first casualty, the biggest loss is what? His freedom of movement. Other freedoms as well, but the freedom of movement mentioned in Article 19(1), that is directly lost, and therefore jail is certainly the biggest restriction on right to life, Article 21. Right. So what happens is when a person is sent to jail, then he cannot live his life fully. And if the jail term is unusually, unreasonably harsh to the person, then the problem starts. So jail is directly connected with the fundamental rights. Now here we said that what about the human rights? So you have to understand that Menaka Gandhi case, Menaka Gandhi judgment, 1978, the Supreme Court said very clearly that human rights in India shall be presumed to be included in Article 21. So with this matter, what we can do here is that Article 21, whenever it comes into picture, human rights will already be the part of that game. So when a person is in the jail, he has committed something wrong. He must not be having some inherent right to be let out from the jail until he completes the sentence. Then why this is issue? Why we are understanding or trying to understand that a jail is something which is not good. Jail is something which is not good. So jail is reasonable and can also be unreasonable. So point here is that jail sentence, jail term is reasonable for convicted criminals, convicted persons, right? The court has pronounced that you are guilty and some punishment has been announced for you, rigorous or simple imprisonment, and after that you have been sent to jail. So it is reasonable and accepted. The jail term becomes unreasonable for under trial prisoners. Why? Because it is against the presumption of innocence. Presumption of what? Innocence. Innocence. So nobody should be presumed, everybody has to be presumed innocent until they are proved guilty. In this basic natural justice principle is violated in the jail term for the under trial prisoners. Under trial prisoners. And this is where the topic bail or jail becomes very important. So before I go ahead, you can see where we started. So bail or jail, rights are impacted. That's why it has become important. Rights are impacted. Rights can be, of course, human rights or fundamental rights. After Menka judgment, human rights are part of Article 21. Then we try to understand that detention leading to jail violates freedom of movement 19(1) and other rights as well, and also restrictions on right to life, because life has to be given a widest possible interpretation, and it becomes unreasonable for those people, those persons who are under trials, they have not been convicted. Under trial prisoners are those prisoners who have not been convicted. So their presumption of innocence principle is violated, which in itself is the crux of the human rights situation. Human rights situation. Now, even for the convicted persons, the jail has to be reasonable. It cannot be presumed that jail term is automatically reasonable for all the convicted persons. Because even if the court has convicted that person that he has committed a crime and must be given 10 years or 20 years of the sentence, we have to understand that he should be treated with what? Dignity. And he must be provided the possible opportunity to develop himself. To repent, to say sorry. And this he can do by doing something positive and meaningful for the society. So, there is one very famous Sunil Batra case. You know, 1990. You can similarly have a D.K. Basu case related to torture. In Sunil Batra case, Supreme Court said that unusually harsh treatment to the prisoners, the convicted persons, shall be violation of the Constitution. This should be treated as the human. And Supreme Court, after this judgment, he also accepted that writ petitions can be filed by such people through simple information given by a letter or something like that. So epistolary jurisdiction also accepted in this case. So even the convicted people must be having some kind of well treatment, good treatment, only then their rights can be there. But we have the problem of what? Under trial prisoners. Under trial prisoners, right? According to the report, under trial prisoner report status of India, 75.8% of all prisoners in India, in jails of India, are What? Under trials. And significant number of these under trial prisoners are first time offenders. First time offenders. So we have to treat them. Now the urgency which Supreme Court has set on the issue of bail in releasing various AAP leaders, Aam Aadmi Party leaders in Delhi, alcohol scheme, or the Jharkhand Mukti Morcha leaders who were arrested, Supreme Court has said one thing very clearly again and again, that bail is norm, jail is exception. Bail is norm and jail is exception. Now the mindset of the lower courts or even perhaps the high courts has become in such a way that they are so averse to giving bail that Supreme Court has taken the baton in his own hands, and again the judges of the Supreme Court has re-emphasized that we must give bail if all conditions are met. So bail should be a right of the person. Right of the person. In this case, what we have very interesting is we have recent Bharati BNSS, which is called Criminal Procedure Code as such. ठीक है? Criminal Procedure Code. There is new section 479. तो सेक्शन 479 of the BNSS, भारतीय न्याय संहिता, साक्ष्य संहिता, CRPC, इसमें ये लिखा है that first time offenders completed 1/3 of maximum punishment, 1/3 of the maximum punishment must be released on bail, and for other offenders it may be half of the sentence which was earlier given in the older CRPC. So first time offender, if they have completed 1/3 of their maximum sentence in the jail, all such under trial prisoners should be released from the jail. Now this has been taken cognizance by the Supreme Court. Cognizance by the Supreme Court, and Supreme Court has said very clearly it has sought a report from Under Trial Prisoners Review Committee. This is the Under Trial Prisoners Review Committee established in every district of India. And so they have sought report from every jail authority in India that how many people are supposed to be the beneficiary of the new first time offender bail release law. And according to the report, as I said, Under Trial Prisoners report, more than 4.5 lakh prisoners shall be eligible for the bail. Now, this is a revolutionary step in the criminal justice reform system in India. A revolutionary step. And what we all have to understand, that when these people are actually released, then the human right regime shall be strengthened in India. The burden on jail will reduce, which are over populated. The jail capacities are running at 118% of their capacities. Moreover, people will get the chance to actually realize their mistake and live as the mainstream person in the society, to repent themselves. So not only human rights, but also criminal justice, judicial burden will reduce, jail burden will reduce, cost for this litigation will reduce, court pendency will reduce. So this law is having the potential actually to impact the criminal justice reform system in India, and the time has come where Indians and Indian system must realize that we have to develop a reformatory judicial system from the revengeful mindset that we might be having. And in this, the bail versus jail, that is the first thing that we had, is going to be the most important, and we have to realize that bail should be a right of the person.